Good morning and welcome to the BDO Public Sector Update. My name's Greg Rubins and I am the lead partner for Public Sector in BDO. And if we move to the next slide, you'll see we've got an interesting set of speakers today. We're going to be covering areas such as data transfer, digital change and flexible workforce structures. And just a few ground rules for today. Please remain muted through the main session so that we don't get any noise interruption. And please use the Q&A box on Zoom to raise any questions or comments to the panel, and we'll deal with those at the end. So please use that as we go along. And a final point is that we will be recording the main session so that we can circulate it afterwards. So just after that, I will give a little bit of an introduction in terms of the context for today. If we can move on to the next slide and the one after that. So just to give a little bit of context, and none of this will be a great surprise, I think, to you, but some of the main factors that we're all dealing with at the moment. Clearly, there are pressures on budgets, and that's the normal pressures, but particularly caused by recent events with public finances and inflationary pressures as well, causing, I'm sure you'll all realise, massive pressure across the public sector at the moment. We also have issues around staffing and workforce, vacancies, issues over pay, strikes, low morale, all impacting public sector. And there are issues around IT and digital as well, the need for more investment in IT to improve efficiency and productivity, but also the threats of cyber attacks. And all of that is impacting on service delivery that we see every day around the health service, education, transport and other services. So that's why we're particularly focusing around the IT, data and the workforce issues for today. So I'll hand over to the first speaker, which is Alexandre from our Digital Risk and Advisory team to talk about UK data transfers.
Thank you, Greg. Right, so Ben, could you go to the next slide? So good morning, everyone. And today I want us to go through two key topics. The first one and the primary focus is the overview of the UK data transfer regime and recent developments. There have been quite a few since obviously the introduction of the GDPR, and then after Brexit and in particular the last year. These we will all cover in the next few slides. And also I wanted briefly to touch upon the Transatlantic Data Privacy Framework. This is a new data framework which is touted as a replacement for the infamous Privacy Shield, which was invalidated back in 2020. So this concerns free data transfers between the EU and the US, but might have some implications for the UK as well. Next slide, please. So in terms of UK data transfers, there are probably four key questions that we need to consider. And the first one is there a restricted transfer? And we will look into what that is. And then if we have identified that there could be a restricted transfer in place, then we would move to look into whether the jurisdiction to which we're transferring data is covered by the Adequacy Regulation. If not, then we will look into appropriate safeguards, and if even that should fail, there's potential for us to rely on any exceptions. And we'll be fleshing this out in a moment. Next slide, please. So in terms of what is a restricted transfer, so when deciding whether you need to consider all relevant requirements and safeguards under GDPR that apply to international data transfers, the first thing you have to satisfy yourself with is whether or not you're actually dealing with a restricted transfer. And there is a three-element test, and the first question you are looking into is whether the UK GDPR applies to the processing of the personal data that you're transferring. Now, GDPR could apply for various reasons, and for public sector organisations, this would typically be because the data processing takes place within the context of an establishment of a UK organisation. Now, I understand that it's quite a mouthful, but what it essentially means that you get a UK organization that processes data, and the processing takes place in the context of its activities within the UK and its activities within sort of the context of the UK organization's operations, then the UK GDPR would apply. To cut it short, basically, most public sector organizations, most data processing activities that you undertake in relation to the data of the UK data subjects would be captured by the UK GDPR. Now, for private organizations, private sector organizations, another element to consider could be whether or not they're offering goods and services to UK data subjects, but of course, taking into consideration the specifics of the public sector, this is unlikely to be relevant. Now, the second point is whether the receiver is located in a country outside the UK. Now, this can sometimes seem quite obvious. Of course, it's quite easy to establish whether the organization is located outside the UK, but sometimes there could be the data transfer arrangements can be quite complex. And normally the questions we get is as follows. For example, when there is a UK controller, so a UK organization that contracts a processor that's also located in the UK, but the arrangement implies that the UK processor will then transfer or engage a sub-processor in a different jurisdiction, let's just say India. And the question is, who is doing the data transfer? Of course, it is true that the data is still under the control of the UK controller, so the organization which actually owns the data and determines means and purposes of the processing. But because there's no direct transfer between the UK controller and the Indian sub-processor, the data transfer is actually taking place between the UK processor and the Indian sub-processor. So in this case, while there is, in the context of the whole arrangement, data transfer, the receiver being located in India, there is no direct data transfer between the UK organization being the controller and the sub-processor located in India. So in this case, you would not typically be captured by the restricted transfer requirements. So again, data transfer arrangements can be quite complex. And if you have any questions, it's always best to either consult the ICO's website or your relevant services provider. And the third element here is that the receiver is a separate controller or processor and is legally distinct from the exporter. The exporter being the organization that actually transfers data. Again, for public sector organizations, this is probably not the most relevant aspect, but for private sector organizations, this could come into play where, for example, the transfer takes place to a branch located in a different country. And of course, a branch not being a distinct legal entity, then this element would usually fail and there would be no restricted transfer. Next slide, please. Now, of course, after identifying the restricted transfer, the first thing you would look at is whether the jurisdiction is covered by, by adequacy regulations. So adequacy regulations, or sometimes in the EU referred to adequacy decisions, are essentially official declarations of a jurisdiction as providing adequate safeguards for the rights and freedoms of data subjects. Now, it is not surprising that the UK has followed for a while the EU's approach. So following the Brexit, most of the adequacy regulations, decisions that have been issued by the European Commission were also transposed into the UK's domestic law, meaning that obviously, most of the European Economic Area countries and EU institutions are covered by the adequacy regulations in the UK, but the list also includes all the countries and territories, as you can see in 05, that were covered by the European Commission's adequacy decisions, but these were in force at 31st of December 2022. For example, this includes full adequacy in favor of Isle of Man, Israel, Jersey, and Switzerland, and partial adequacy for Japan and Canada. Now, partial adequacy means that not all data processing activities in the jurisdiction are covered. It could be certain processing activities, for example, in private sector or under certain law. And again, the key here is to note that not all future decisions by the European Commission will be automatically considered as relevant for the UK. And this will come into play later on when we discuss the new data privacy framework with the US, between the EU and the US. But the good thing is that if we look at O3, countries, territories and sectors covered by the UK regulations from 1st of January 2021 means that the UK can now issue its own adequacy determinations, and the first ever adequacy determination to be made independently of the EU by the UK was quite a recent one, and it was with the Republic of Korea or South Korea, which means that all data can flow freely. In essence, adequacy regulations means just that. If you have this in place, you can transfer the data as if you're transferring it within the UK without any additional safeguards. Or to cut it shortly, it just means free flows of data, which of course alleviates a lot of burden for organizations as well as costs. Now, if you don't have adequacy regulation in place, you will then consider implementing an appropriate safeguard. And that's something we will look at on the next slide. Appropriate safeguards are additional tools to implement where you don't have an adequacy regulation. And these are just a few examples. The actual list is quite long, but I've just taken those ones which would be far more relevant for public sector organizations. And the first one is a legally binding and enforceable instrument between public authorities or bodies. Now, the first thing to look at is that the instrument has to be legally binding. In other words, it has to provide for binding and enforceable safeguards for data subjects, in particular their rights and freedoms, and this should be enforceable in the destination jurisdiction. What it also means that you have to have a public authority or a body, and this can be quite broadly interpreted. So most of the time it would be based on the domestic law of the country where the data are being transferred, and can be quite broadly interpreted so as to cover all types of organizations, from ministries and public bodies to other legal entities set up under the public law, for example, certain schools or universities. As well as, according to the European Data Protection Board, it could also involve international organizations set up under the international public law. So as you can see, this is a quite broad term which can capture many organizations. And again, it has to be a legally binding instrument which differentiates it from the administrative arrangements, which we'll come to just in a second. Next one, and probably the most commonly used one, are standard data protection clauses, which in the UK we now refer to as International Data Transfer Agreement, or IDTA, or International Data Transfer Addendum, or sometimes just referred to as the UK Addendum. We will briefly discuss what these are in a second, but essentially these are the UK's version of the previously known standard data protection clauses, or standard contractual clauses. This can be entered into with any organization. So in other words, if you're not entering into an agreement with another public body or authority, you can simply rely on this UK IDTA or the addendum. For example, if you have an IT services provider in a different jurisdiction, which is not covered by the adequacy regulations. Now, in addition to these two, you can have, subject to specific authorization from the ICO, bespoke contractual clauses that need to be approved by the ICO and therefore are quite rarely used because it can be quite onerous and time-consuming. But nevertheless, these are one of the options, as well as administrative arrangements between public authorities or bodies. Now, as we previously highlighted, the difference here is that these administrative arrangements are normally not legally binding, for example, memoranda of understanding. And therefore, when we are dealing with issues of transfer, which are non-binding, this would have to be approved by the ICO to ensure that there are relevant protections for the rights and freedoms of data subjects. As I already mentioned, these are just a few examples of appropriate tools that could be relied on by organizations and most relevant ones to the public sector. But we also have other possibilities, including, of course, binding corporate rules, which are less applicable to public sector organizations, as well as codes of conduct and certification mechanisms, which haven't been approved thus far, specifically for the UK. Moving on to the next slide. Now, I want us to look a bit more into the IDTA and Addendum. Now, IDTA is a standalone contract. It basically encapsulates everything it needs to in order to be an individual and a standalone contract and be an appropriate transfer tool and replace the EU SCCs. Sorry. So, for example, if you want to rely for a UK GDPR transfer, you can just simply execute or sign a UK IDTA, and it's a general tool for all transfer cases. It's a single template agreement. It does not contain any specific modules that you need to amend, but it's got certain contents that I want us to briefly just go through. Part 1 deals with parties and signatures, transfer details, including the linked agreement. So the linked agreement is an agreement under which the data transfer is taking place. So in other words, a commercial agreement. For example, it could be an IT services agreement under which then the data transfer agreement would sit. It also includes fields for transfer data, security requirements, etc. Part 2 deals with extra protection clauses, and these would be fed into based on the transfer risk assessment findings, or TRA. We'll come back to these in a bit. Part 3 deals with commercial clauses, which could also include in this agreement from the linked agreement, which we already mentioned. And Part 4 are mandatory clauses, which cannot be amended. So the IDTA in this term is quite prescriptive. Now, for the UK Addendum, we have found that most organizations prefer to rely on UK Addendum because it can be used together with the EU SCCs. So there's no need for a new agreement in the form of an IDTA. In other words, it is appended to and incorporates the EU SCCs. And the contents could broadly divided into 2 parts. First part is deals with parties, selected module from European standard contractual clauses, relevant clauses and appendices for the appendices, of information. So in other words, what it really deals with is you have to select which of the modules you are relying on from the EU SCCs. And also deals briefly, and it also provides mandatory clauses to amend the European European SCCs to tailor it to the UK regime. Now, to put it into context, what it really means is that instead of relying on a separate agreement in the form of IDTA, you can just simply execute a UK addendum. So if previously you have relied on EU SCCs for your data transfers, you can just simply execute a UK addendum without the need to have a separate agreement or IDTA and consider separate regime too much in order to comply with the UK law. In other words, you will have one single tool that you will rely on for both the EU transfers as well as the UK transfers. And of course, in order to comply with the UK regime, we'll just have an additional document which just appends to and complements the tool that's already in place. And again, this is the reason most organizations just rely on this tool is because they are exposed to EU data transfers already, or they have been dealing with the EU standard contractual clauses already and find that this is a more familiar and useful tool to be relied on. Moving on to the next slide, let's go through briefly of the developments in terms of data transfers. And as you can see in blue, this follows the developments in terms of standard contractual clauses in the EU. First, they were adopted in 2021, and then for any new contracts, the new SCCs could be relied on from 27th of June 2021. And then from 27th of September 2021, the old SSCs can no longer be used for new deals. And then jumping to 27th of December 2022, all the EU SSCs can no longer be used for transfers under the EU GDPR. So all contracts have to be updated. Now, the way UK deals with this is a little different. So in 2022, as you can see in grey, the ICO introduced, and then it was approved later on, these new tools for UK transfers, the IDTA and UK Addendum. So they came into force. And then on 21st of September, the transitional period ended, which means that all new contracts have to be based on IDTA or UK Addendum. So if you're entering into new contracts which involve data transfers, then you would have to rely on the IDTA or UK Addendum unless you're utilizing any other tool, which we already discussed, for example, a binding agreement between public authorities. Now, in November 2022, an important change took place, and the new transfer risk assessment guidance was introduced together with a tool. And I will come back to it on the next slide because it's a very important thing. And then we have a deadline on 21st of March 2024 in relation to IDTA and UK Addendum, meaning that all contracts have to be updated and based on the IDTA or UK Addendum, similarly how it happened for the European SSCs, meaning that all your contracts would have to be based on these tools that were introduced in March 2022. Now let's move on to discuss what the TRA is, transfer risk assessments, which you might also come across the term transfer impact assessments, which is used in the EU. So we've got two broad options here. And the first option is the ICO's approach, and the second option is the European Data Protection Board's approach. And what transfer impact assessments or transfer risk assessments essentially are, it's basically an additional requirement following the very famous Schrems II judgment. These are tools need to accompany the transfer tool, which we already discussed, for example, UK IDTA or Addendum, in order for you to verify that the jurisdiction to which you're transferring data provides proper and appropriate protections for the data subjects. Now, the first option is the ICO's approach, and it compares the position of data subjects and the risks to their rights between the information remaining in the UK as opposed to transfer going ahead. And it focuses on human rights in the destination jurisdiction, as well as topics such as recognition and enforcement of a court decision or an arbitral award in the destination jurisdiction. So it is a very human rights-based approach, considers also the data protection aspects of the human rights framework in the jurisdiction of the destination country, and also looks into whether or not any decision would be properly enforced or recognized and enforced in the destination jurisdiction. Because of course, if you have a court decision in your favor, you would then be expecting that if you take it to the destination country, you'll be able to enforce it properly. In other words, if there's a rule of law and courts are independent and unbiased. Now, option two is a slightly different approach from the European Data Protection Board, and the focus is again on the comparison of the laws and practices of the UK to those of the importance jurisdiction, with the focus being all issues surrounding potential third-party access, especially by governments. Now, again, both of these approaches are equally valid, and both of these approaches aim to inform and support the data transfer tool that you will be relying on. So after you have done your assessment and verified that the jurisdiction is safe to transfer, you can then proceed to rely on the tool, one of the appropriate safeguards that you have identified. If you fail that assessment, one thing you can consider doing is actually implementing supplementary measures. Supplementary measures aim to support those measures which are already identified in the relevant transfer tool to make it more robust. It could be all types of measures from technical, for example, you can include encryption, extra encryption measures, or it could be contractual measures to make sure that your contract provides far stronger safeguards for you to be able to protect the information about the data subjects and better to more to facilitate the enforcement in the destination jurisdiction. Again, these are quite complex matters, and we have in fact prepared a short article, which I will link in a bit in the chat for you to look into whether you want to expand your knowledge and understanding what these data transfer risk assessments actually are and how best to how to comply, how to carry them out, and how to comply with the existing data transfer regime requirements. Moving on to the next slide. Now, there is a certain way for you to transfer the data to a different jurisdiction by relying on exceptions, or sometimes called as derogations. Again, these are, as the name suggests, exceptions to the general rule, and our clients, rightfully so, actually try to avoid relying on them too much, because these are for occasional transfers, one-off transfers where you don't really have to use the appropriate tool, one of the appropriate tools which we already discussed. And we have here a few examples. For example, explicit consent, important reasons of public interest, necessary to establish legal claim or defense, to make a legal claim or to defend a legal claim, etc. It could also include vital interests of the party, and so on and so forth. So these are, again, one-off tools and should not be relied on too much unless the circumstances of your transfer are such that you can actually use this in relation to, for example, significant risk data. Again, this is a quite complex matter to be covered within this time frame, but I wanted to highlight that this is one of the possibilities for you to rely on, where all other tools and all other possibilities fail, as long as the circumstances allow you to use, for example, explicit consent. But considering that it could be quite difficult or onerous to obtain explicit consent of all parties, or to try and squeeze your data transfer circumstances in one of these derogations, considering all these difficulties, it might be more appropriate to actually suspend your transfer and not transfer the data to the given recipient in a destination country. Now let's move on to the next slide. I wanted to briefly touch upon the ICA's revised approach to enforcement. And you might have heard about this, that the ICA decided to use its discretion to reduce the impact of fines on the public sector and use its wider powers, including warnings and reprimands. And this would be trialed for 2 years. It doesn't take away from the fact that any reputational damage or the loss of the public's confidence would still remain important considerations, given that the public sector engenders, and it ought to engender, a higher degree of trust amongst the public. And the ICA's discretion, again, doesn't mean that it will not employ its powers to impose a fine, even if its broadest, so this very broad stroke approach is that it would try to reserve fines for the most serious of cases. Again, I just wanted to briefly outline this new approach of the ICA, which will be trialed for 2 years, and we will see, hopefully in 2 years, what a report from the ICA about the impact or the implications of this new approach. But again, I want to highlight that this doesn't take away from the potential for reputational damage or the loss of the public's confidence in a relevant public sector organization. Now, moving on to the next slide, this is the second topic that I wanted to cover briefly. And for those interested, I will also send another link to an article prepared by BDO for a bit more deep dive into what transatlantic data privacy framework is. But essentially, it is touted as a replacement for the Privacy Shield, which was invalidated under the Schrems II decision. You should go to the next slide, please. And what it offers is free flows of data between the EU and participating US companies. Now, of course, it will be an instrument for the EU to use. However, if the EU indeed issues an adequacy determination for the US. Of course, the UK is likely to follow this suit as well. And in fact, the UK, I think it was in 2022, has identified US as one of the priority destinations in favor of which an adequacy regulation is to be taken. In other words, if the EU successfully passes an adequacy decision, it is very likely that we will soon see a corresponding determination by the UK authorities of the US as an adequate jurisdiction. Again, if I want to highlight that if this does take place, there will be no direct impact for the UK organizations, but it is likely that we will see some results, or that it is likely that the UK will follow the suit. However, this is not without potential roadblocks, and it's possible that we will see Schrems 3 decision. So the organization, None of Your Business, which was co-founded by Maximilian Schrems, has indicated that another challenge is likely. And I didn't want to go through the details of what the challenge entails. You can find those in the article that I will just link in the chat. But essentially, the concerns are quite similar to those already expressed in a Schrems 2 decision, and it will be very interesting to see how this pans out and whether we will see, in fact, Schrems 3 decision invalidating this new data privacy framework. And that sums up my presentation. And if you have any questions, I would be happy to answer in the Q&A session. And before I go on mute, I would like to present the next presenter. Next slide, please, Ben. Bill Mitchell, a director at DRAS, or Digital Risk and Advisory Services, will be talking about delivering digital change. Bill?
So I'm a director in BDO's Digital Risk and Advisory Services team, and I've been advising and auditing many digital strategies and transformation projects and programs over the last few years, including central government departments, ALBs, regulators, and quasi-commercial businesses. Quite often it's the case that need to reflect on the key learnings to consider and watch out for. So I'm going to present some of those today to give you an idea of some of the things that have come up, some key particular things that I found that are particularly relevant. So first of all, I'm going to move on to the first slide there, key steps for consideration. And this refers to being clear about some of the things that you need to consider right at the start. And giving the context of this is referring to projects particularly relating to where you've brought in an external digital team, which has been appointed from the outside to perhaps transform digital services in your organization, and customer and possibly where you've got a situation where you've both got customers and internal staff impacted, for example, such as the major CRM implementation. And I'm going to touch on both the development and the actual kind of running of the software as it goes live. So the first thing I wanted to talk about is have well-formed outcomes from the start. Being clear and with all parties aligned about what the mission, values and purpose on your organization and your digital strategy and transformation activity, however big or small, maximizes the probability of success. So it's important to be clear what you want and why you want it. It's no point in having fuzzy or different wants across different stakeholders, which can happen. What will the new way of working and work experience feel like for staff? How would it look and feel like? Not thinking through those wider implications of change on stakeholders, whether it's staff, users, customers, those that are in charge of governance. Being clear on what that is really important. Being clear also on when you have arrived at your destination and what that exactly looks like. But it's also important to ensure that you try not to do everything all at once, because you're bound to fail. And certainly my experience of the case is that you need to break down a digital strategy or transformation program into logical parts. You need to also understand the context and the boundaries. Quite often what happens is, of course, with the boundaries is they fluctuate over time, either because the ambition is too great, or there is a scope creep as people want to add more things to the digital strategy. Alternatively, they're just simply overambitious, and then you go down to a very small minimum viable product, which actually achieves nothing or very little compared to what was expected. So being very clear at the start about boundaries is really important. But also, I think it's subtler. There's a kind of more cultural piece that I'd want to make sure that is really covered here as well. In having a compelling outcome and wider implications are fully understood. So, for example, the purpose may clash potentially with values or cultural norms, such as it may require staff to be more tech savvy or just simply understand agile project management terminology. I'll talk a little bit about that in a while. A second key area underneath that is that a key step to a process of developing a strategy is to have an iterative development of a digital strategy. There is a tendency to start off with devising your organizational strategy, then digital strategy, and then crack on with the implementation. But that, in my experience, is not the way to go about it. What I've found is that it works best when digital strategy is formed in at least 3 iterations, each successive iteration unfolding in more detail from the previous, but interacting and referencing back to the organization strategy. So the first kind of iteration is considering what are we trying to actually do? Linking then to your vision. What digital innovations can do to extend our mission, values, and our strategy? Quite often, and certainly my experience just very recently when we're looking at improving and our internal audit software within our team in BDO, is you need to go out into the market to find out actually what digital can actually do. And sometimes it can go beyond what you're expecting, and therefore affect both in terms of your approach to digital strategy, but actually your approach to strategy altogether. So what we suggest as a good way of doing it is start of a first wave is develop a series of what you might call user epics, which are very high level walkthroughs, if you like, of the key purposes of what you're trying to do from your usually around what your organization delivers, the service it provides, for example. That may then, once that is done, is to then develop a more detailed set of user stories, again, providing the linkage between what you're trying to achieve at a more practical level, more detailed day-to-day level, and that digital environment. Another tip to mention there is don't or avoid as much as possible defining the solution in the problem statement. So, for example, I'll give you an example. Let's say you say your part of your digital plan is, well, we're going to introduce a new staff expense system, and therefore we need to have scanners so people can scan all their receipts. Now, of course, if you went out into the marketplace today, that's very old hat these days, because of course people upload their receipts using the camera on their phone. So this is a reason why needing to think very carefully that not defining the solution into the problem statement or what you're trying to achieve. By doing this in this way, in this stepped approach, by going to more detailed levels in each iteration, we are also suggesting that you have an approval for each of those stages. So each stage, as you go into more detail, gets the sign off at senior level before you move to the next stage. It also ensures a reference across continually through the development of these cycles to your business mission and values and what you're trying to achieve. It also helps to improve your benefits realization, and also it makes your digital strategy much more part of strategy. However, one thing I should say is really important, and what people make mistakes on, is not doing enough solid and inclusive audience research. And audience, I mean the full range of stakeholders. So it's important that everyone gets engaged in the process. Moving on to the next slide on hints and tips. So this leads on to my first tip, really, is really take time to understand and engage with your user and audiences. Get those well-informed outcomes at this early stage. This is really critical part of it. But in spite of having well-formed outcomes at the start, it is possible for things to go awry, in the sense that actually, as a project starts to unfold, a digital strategy is implemented, it is possible that actually things have moved on technologically, or perhaps in terms of your mission and what you're trying to do. So therefore, there is no harm in being prepared to change mid-course, or at least subtly change direction partway through a strategy. Now, I've seen this done, and I think done in the right way through a proper change control mechanism works really well, because what you avoid is at the end of perhaps a 3-4 year program, arriving at a destination which is actually 3 or 4 years out of date. So it is important as well that linked in with that, to be prepared to take some risk. Ensure that your stakeholders, especially senior management, have the same appetite to taking risk as you, of course. Ensure and keep checking that the digital is embedded within the business strategy planning as not an adjunct to it. And when implementing digital strategy in daily work, but this can lead to some shifts in either work patterns, job content, especially if the digital team is from an outside body organization, or is just being brought in with the expertise. One of the risks I've noticed is that when this happens, is that often unusual new terminology is used and can really flummox and alienate and cause interactions between existing staff and those people that are working, delivering the project, because they're using terms, perhaps using agile project management terminology and methodologies. So I think that's a really key thing there, is to make sure that you bring people with you. An example of that is particularly where you have existing staff that really need to be part of the digital transformation. For example, if you're building a new interactive website, a lot of the content will be provided by individuals that are from the existing staff. That's where the knowledge comes from. So those teams will need to work closely with the digital teams. So it's really important that you support them and educate them and train them. It's important that you recognize that there'll also be a cultural difference. Otherwise, introducing digital ways of working can create that animosity and tension, and I've seen that happen. One way of getting around that, in terms of a hint and tip, is to actually, for those that are implementing digital, is to provide good evidence base to say that this is the good way of working. So moving on to my final point, some of the pitfalls. I'm an internal auditor, and you might be surprised to me to say that one of the biggest risks I find, and in fact in some of the really big, much you might think are the most forefront organizations, is that they are under ambitious about what they can do in their digital transformation. There is a tendency at a small or large scale to replicate what we did before with the old system, or what we used to do manually. Having that first iterative wave of understanding what digital can do for you is really important, to open your eyes to find out what it can really do, and to explore new ways of interacting with your members of the public, your customers, and the way that your staff will work. I suppose a way, a rule of thumb is that if no one notices anything different, we've probably lost an opportunity. If it's just fixing the website, it's not a digital transformation. A second pitfall is not having sufficient skills or not taking your organization or users with you. Therefore, it's really important, as I mentioned before, particularly where you're heavily involving existing staff, either in the development of the digital offering or actually using the kit once it's implemented, to bring them along with you, to debunk or demystify the terminology such as scrums and all those sort of things that you talk about with agile project management methodologies, which are quite synonymous with digital transformation. Always provide that evidence base and ensure that digital strategy is in bite-sized chunks. One major digital transformation, as one regulator did a little while back, was focusing mainly on the user access, external access to the website and particular information. That was really only the start of the journey. It's important to recognize that digital transformation is a continuous activity. In doing so, it's also important to recognize that you may have adopted and employed for a temporary basis a digital team to push forward a digital transformation. It's really important that those skills are transferred or retained within the organization to support both the ongoing support for that particular technology, but also for future development and upgrade. So that really concludes what I wanted to say about my digital strategy and some of the thoughts that I have about my experiences of looking at organizations. Next, my colleagues, Caroline's and Jackie, are going to speak about the implications of a flexible workforce.
Thank you very much, Bill. I'm going to kick off this section, which really will be looking at the impact of the high inflation economy for employees and employers alike, and looking at what that means from an employment tax perspective. In particular, we'll be looking at flexible workforces and the issues that come along with those. So kicking off with the next slide, please, Ben. Thank you. Oh, and again, so there's lots of information about us there that I don't need to go through, but kicking off with the latest ONS data, which is from their report dated the 17th of January, which covers the period to the end of November 2022. We've got some very interesting statistics. So first, if we look at the unemployment rate, that's currently at 3.7%. It's largely unchanged. It still stands at 1% less than pre-pandemic. Now, there's an interesting context to that because there was a report published by an organisation called Career Wallet quite recently, which highlighted that employees have been so significantly impacted by the cost of living crisis that more than 1 in 10, or in fact 14%, have had to find a second job to keep them going through the current cost of living crisis. So what that impact is on the unemployment rate, I think we'll see as we move forwards through the next quarter. We'll look at the next set of ONS data when it comes out. So that leads on to vacancies. We're currently at 1.161 million vacancies. That's been falling for the last 6 quarters. It's relatively high. That reflects uncertainty. And again, the context of that around people taking second jobs is interesting. The economically inactive has decreased by 0.1% in the 3 months to November 22 compared to the previous quarter. The interesting part there is where that has come from. It's not a huge decrease, but the profile is really interesting because it's at either end of the scale. Really not much change in the middle. But if you look at the youngest group, so up to 24, and the oldest groups, so around about 60, that's where you've got movement, and that's largely down to students in full-time education, illness and retirement at the other end of the scale. Payroll employees currently standing at nearly 30 million, that's up 28,000 in the 3 months to November 2022. We have seen a continuing increase since 2020 in the number of employees who are returning to the payroll after the lockdown version number 1. Lockdown version number 1 saw a peak of self-employed people standing at around 5 million. Unfortunately, not everybody could be furloughed. There were people who lost their jobs at that time, and therefore they got out. Well, they didn't get out, they stayed in and did something different for themselves, set up their own businesses and increased the number of self-employed. That has been going down. It's now standing at 4.2 million as people return to jobs on the payroll. The redundancy rate remains low. It's currently 3.4 per thousand in the quarter ended November. So going on to the next slide, please, Ben. Thank you. So what are we seeing in the public sector? The interesting figures are around pay increases. So pay has increased. I don't need to tell anybody on this call that those are below the cost of living increases. The growth across all sectors was 6.4%. Now that's around 7.2 in the private sector and 3.3 in the public sector, but perhaps more meaningful are the big figures on the screen. Now those are the median base pay awards, so we're not skewed by large increases at the lower end due to national minimum wage, for instance. So median, public sector 3.8, private sector 4%, so not a million miles apart. Private sector is up from 2% in the same period to end of November 21 and up from 1.4% in 2021, again weighted to employees at the bottom end of the pay structure. So data has shown us that also a quarter of pay reviews take place in January. So it will be really interesting to see what the data says in the next ONS report, which covers the following quarter, because we're looking at slightly out of date information there, because that's all that's available. Real terms, inflation caused pay to fall across the board by 2.6%. That's a result of CPI going up by 10.7 in the 12 months to November 22, which is down a little bit from the 1.1 in the 12 months to October 2022. What I don't need to tell anybody, and particularly anybody who walked to work past a hospital this morning and went past the nurses striking, as I did, and as Caroline, my colleague Caroline, you don't have to be called Caroline to work here, but it helps. But my colleague Caroline also walked past the hospital, past the placards this morning. We currently, as at the end of November, had 467,000 working days lost due to labour disputes. That's the highest since November 2011, and it has only increased in the intervening period. Today and this week we have some of the highest numbers of health service walkouts, I understand, since records began. Now, where we're at is a very difficult position, and this is not just public sector, this is reflected across the board, because we're getting warnings from the Bank of England that if we give higher pay rises, the risk is that inflation levels could become embedded. Will we see inflation going down if we give cost of living increases to the workforce? So there we've got a really difficult stress between employees needing more money so that they don't have real term pay increases, an increasing base cost for employers, not just in pay increase, but in cost of power, other inputs, cost of managing the day-to-day operations, cost of working capital going up, interest rates going up, and competitive labour market. It all leads to a really difficult business environment in which to justify pay rises. But equally, you've got a war for talent. You need to bear that in mind, because you need people in order to operate businesses. The other side of that war for talent is that we're seeing hybrid working being seen as a must-have by many applicants. It makes recruitment tough. It's not possible in some roles. You have to be on site to do certain jobs. But for others, we have pressure from people coming into the workplace who want to be doing hybrid working, against pressure from management who quite often want to see people returning to the office, particularly in order to retrain or train people entering the workplace. We've got the increases in national minimum wage, roughly 10% across the board, which will bite in April 2023. And it is so easy to get that wrong. We're going to see an increased focus from HMRC on national minimum wage reviews, it's going to be really, really important to make sure that people aren't accidentally getting it wrong. People aren't deliberately getting it wrong, but it's really easy to fall into a bear trap and not pay minimum wage when you think you are. Demand is higher than candidate supply, and looking at the third of employees who are thinking about moving jobs because they want higher pay, it's only going to get more difficult. But contrast that with, is higher pay available? No, it might not be. So the third who want to move jobs because they think they're going to get higher pay somewhere else, is that a realistic expectation? And I think the next quarter will give us an awful lot more information about that. What we are seeing is a move towards flexible working, more agency workers, more people working as freelance contractors, but their contract rates are increasing too. And equally, as I said, it's really easy to get national minimum wage wrong. Again, flexible working through off-payroll labour can be a high-risk environment from a regulatory perspective and from a tax perspective. So I'm going to hand over now through that canter through the economic context to my colleague Jackie Roberts, who's going to talk to you a little bit more about the impacts and issues relating to flexible working.
Thanks very much, Caroline. Yeah, so that leads me very nicely into what are we seeing from an off-payroll labour perspective. I think the first thing to actually point out is that there has actually been a plethora of employment tax legislation that's been implemented over the last 10 years or so. We obviously had the old IR35 rules. We've had employment status since the year dot. Obviously, that's something that we have to deal with all the time, anyone who is engaged directly. But we've had agency legislation, we've had managed service company legislation, intermediary rules called the new intermediary rules implemented in 2014, so really not that new. And now we've got the IR35 rules for the public sector that was obviously in 2017, and then all of the public sector moving into the new rules for IR35 from April 21. So let's think about that with respect to those that are engaged directly. What we're finding is that through the analysis and the work that's being done by businesses and organisations, that a lot of individuals are actually not engaged via a personal service company and are actually engaged directly. And so the risk to a organisation has always been there. Has the individual been engaged correctly on a self-employed basis, or should actually they be an employee? So then we move on to the IR35. So HMRC's view was that before April 21, and in fact I didn't say before April 2017, at least 10% of the PAYE and NIC that should have been deducted under the old IR35 regime wasn't. So they needed some kind of compliance activity or legislation in order to put that right. So what they did was, obviously in the April 17, the public sector went straight into IR35. And now we've got April 21, the new legislation. And what's very important to note is that there isn't just a straightforward change for the public sector going from 2017 to 2021 with no changes in the rules. There were actually a couple of significant changes in the legislation that were only implemented in April 21. What we're looking at for IR35 is where a worker is providing their services through an intermediary, a company or an LLP. More often than not, they would be a personal service company. But before we look at IR35 for the new rules, we always had to be aware that when we were engaging an individual via a personal service company or an LLP, that was robust. Because if it wasn't robust, say the company's actually incorporated outside the UK, or payments were made not directly to the personal service company, or in fact the contract said that the individual was stated within that contract, there would have been a direct engagement. And we go back to the current position there at that second little circle, because it's not an IR35 arrangement, it's not a robust arrangement, and therefore you have to look at employment status. So what this brings us to is we're in an environment where HMRC are scrutinising everything that is happening. They're scrutinising the contracts to make sure that the correct rules are being applied to the arrangements that you have in place, and then applying the legislation applicable. So we're going to move on to a bit more of a recap on actually the IR35. Next slide, please. So what we've got in IR35 is we have an individual that is personally performing or is under an obligation to personally perform services to another person. So in this case, obviously the public sector. And those services are not under contact directly with the public body, otherwise that would be self-employment, but under an arrangement with a third party, and that's the personal service company. So a personal service company can be, it can be just where the services are provided by the individual through a company that they own, where the company is owned by the director, the worker, and they own more than 5% of the organisation or their personal service company. And in an LLP, it would be the same. So if you had an LLP member providing services, if they were in receipt of 5% of the profits, then that would be a personal service company. And finally, a partner in a partnership, if the partner providing the services to the public sector has more than a 60% entitlement to the profits. So personal service company isn't just as straightforward as saying Jackie Roberts to Jackie Roberts Limited. There is a wider definition there. And all of that is the legislation requires you to have a regard for the contractual arrangements that are in place between the worker and the public sector, but not just the contractual arrangements, the actual arrangements as well. And this is borne out by a plethora of tax cases that we see where they're looking at the contract, but also what's happening under the skin of the arrangement. So let's say all those three are in place, then what we've got is the public body, and obviously that would have been 2017 and it's still the same, 2021, needs to make an employment status assessment. Having taken reasonable care with that employment status assessment, they must communicate the conclusion of that assessment and the reason why to the worker or the personal service company and the next one in the chain. So where the public sector body doesn't engage the individual directly through a personal service company, but more indirectly, say an agency, then the communication would need to go to the agency as well as the worker. That was a slight change. And when the chains get longer, then the communication, the SDS, the status determination statement, must be passed down the chain as well as going to the worker. So what happens, so if we've got an employment status assessment where the conclusion is one of deemed employment, our fee payer must operate PAYE in NIC plus apprenticeship levy. The fee payer in straightforward cases is going to be the public sector. Public sector engages the individual via the personal service company. So they are paying the personal service company, but a fee payer could be someone further down the chain that is actually paying the personal service company. That said, if the public sector hasn't taken reasonable care in its assessment and it passes the communication down the chain, then HMRC may well seek the PAYE and NIC from the public sector body rather than the payer, because of course reasonable care hasn't been taken. I'll go into that in a bit more detail. Next slide, please. This is just a simple diagram of the contractual arrangement, just to sort of make it clear that what we've got there is the public body in a contract with the personal service company, and for the personal services being provided, that would mean that a payment is being made by the personal service company. One of the things that was new to the April 21 rules was that there had to be an appeals process in place, which means the public sector body must deal with any appeal from the worker or even the fee payer, if that doesn't happen to be the public sector body, and deal with that appeal within 45 days. So the individual has no time limit on when they can make their appeal. but the public body must respond within 45 days, either saying that they have looked at the facts, the arrangements again, and concluded that they are still, say, deemed employed, or if the facts and the arrangements are different, then a new SDS is sent that would state that the individual is actually now self-employed. So it just depends. Next slide, please. So what we've done, so that's a quick recap on what is IR35, and most people will obviously understand that, but we thought that the most important thing to do here was to highlight what we've seen in the last, say, 23 months, since it's been implemented for April 21. So we've got some interesting issues around the use of the HMRC assessment tool, and I'll go into those in a bit more detail in a minute. Plus, we've got the identification piece. So where are our personal service companies, and have we actually identified all of them? Thirdly, we've got the statements of work. This is something definitely that we see within the public sector, where you might have an individual providing their services, and instead of having a straightforward contract for those personal services, a statement of works is drafted up. The statement of works might not mention the individual personally, but it mentions the type of work that's being provided, the output that's being needed, etc. But it's still a personal service. So as the individual has provided it, there is a very real risk that actually it's not a statement of works, i.e. a supply of service, but actually a supply of labour, very much caught by IR35. We've then got the supply chain due diligence. So if we are looking at identifying our individuals within our supply chain, and we conclude that something's not inside IR35, an example would be where the public sector body has engaged an agency, and there is an assumption that the agency will have had those individuals as an employee. What HMRC are now expecting is a little bit more due diligence to be done in order to confirm that that is the case. Unless you've got some documentation that says that they are in fact the employees of the agency, how do you know that they're not? They could be self-employed, which creates further risks for the public sector body. So we would recommend that there is supply chain due diligence. You firstly find out exactly who is in the supply chain, and then depending on who that is, some due diligence is undertaken to establish that they are definitely employees down the chain. And you may find that actually they're not. They could be personal service companies, again, still caught for IR35, because as we know, it's any personal service company in the supply chain rather than just one that is directly engaged. So then I've said about reasonable care. Now, reasonable care, when we first were talking and discussing about implementing for the April 21 rules, admittedly, was all about reasonable care in how the assessment has been undertaken. Whether you've used HMRC's tool, whether you've got evidence of the output, etc. But HMRC have made it extremely clear that reasonable care is in fact in respect of the whole IR35 process. And I'll go through that in a bit more in a minute. And then finally, you've got the evidence and tracking. So were HMRC to come in and do a review, you want to be able to evidence everything that you've done and show that you've tracked it, show that you've tracked the date that SDSs were sent, even actually before that, the date that the contract was taken on, then the date that the SDS was issued, and the date after that payments made, because of course a payment cannot be made until after an SDS has been issued. Then if there's any appeals, the date the appeal came in, the date the appeal was dealt with, etc. HMRC will want this level of detail in order to be comfortable that you've sufficiently tracked and taken seriously the IR35 process. Next slide, please. So I mentioned obviously in the previous slide about the HMRC tool. So I think I would say that in my experience, probably 90% or maybe even higher of end users do use HMRC's CEST tool. Firstly, it's free, so that's a good point. It's relatively easy to use, and the big plus for any organisation is that if you have a conclusion that's been issued by HMRC CEST tool, they will stand by it. But that is only if the information that is given into the tool is correct. So the bad points around the HMRC and the things of concern are its lack of subtlety. It's very much quite a clunky tool in order to look at employment status. There is never a replacement for the actual use of an individual assessing themselves rather than using a tool. A tool can only ask so many questions. And one of the things that we know about the tool is that it doesn't assess mutuality of obligation. HMRC have made it clear that they believe that mutuality of obligation applies in all instances where an individual is providing services. Interestingly, there are now 10 or so tax cases in the last couple of years where mutuality of obligation was the reason that the tax case was lost by HMRC. Admittedly, there were also 50% that were won, and it's not just mutuality. Mutuality does play a big part in the tax cases. And HMRC's CEST tool is not updated for case law. So, and there's also the problem with entering all of the information and HMRC CEST tool coming out with an unable to determine. So what do we do there? 20% of the cases are unable to determine. Do you just run it? Do you get more information? Do you think about maybe doing your own assessment and using it along with HMRC? So it's definitely something to be thinking about. Next slide, please. So then we talk about the identification. A lot of conversations took place before the rules were implemented, but we still have those conversations now about how have you identified who is in your labour supply chain. Sometimes there's been a bit of an oversimplification of the identifying process. What I mean by that is where you have individuals that are known to the business that are personal service companies. You can see them in the office. You know the particular departments that would have contractors, and therefore the concentration has been on those individuals and the contracts for those individuals, missing out on perhaps apartments and other avenues to providing services altogether. So the oversimplification won't necessarily identify all those personal service companies. One of the areas that we see there is sometimes there's an understanding that the procurement team will deal with all of the personal service companies, yet they might actually come in through not the procurement route. So it's definitely worth thinking about. There needs to be a systematic approach, really, rather than just a spotting who it is. Sort of interrogating or having a system that will interrogate the engagement process, making sure that all business engagers understand what they need to do if they're involved in the first place, rather than HR, because of course we can't have any payments being made until the SDS has been issued. So a systematic approach is definitely recommended. So this will then, with that systematic approach, will lead to actually identifying all of the OPL rather than just the ones that might be spotted. And then finally, with the identification processes, we automatically assume that our end engager or the public sector could be the end engager. But where you have a genuine statement of works, where you are engaging not an individual providing labour but services, there is the distinct possibility that you have engaged an arrangement outside of IR35. And we would recommend that if that is the case, if there's a genuine statement of works for the supply of service, then a record is made to confirm this, the assumptions that were made, so that HMRC, if they were to inquire, would understand the conclusions that have been reached. Next slide, please. So I mentioned about reasonable care. What we've seen is that IR35 touches many parts of an organisation: HR, procurement, perhaps IT, payroll, etc. And in order to demonstrate reasonable care, we think that it's important that all of the key stakeholders are involved in the process, rather than it just being passed to one part of the organisation. Or good communications, that's another thing, could have one owner, but definitely all areas need to be considered. And then the policies that are implemented need to express who it is that has responsibility for what part of the process, so that HMRC can understand that. HMRC at the end of the day are looking for quality processes and policies, as well as I said, the employment status assessment itself. So it's having the visibility over all of that in order to ensure that the process is robust. And as I say, basically you want good communication both internally and also externally with the SDS process. And the final piece is that future proofing. So if you've got a good process, you need to make sure it's continued to be fit for purpose. Fit for purpose in terms of the policies and moving with the times of what the organisation is doing, but also the individuals within the engagement, checking that their services haven't changed in any way. We would recommend probably reviewing contractual arrangements with those that are in your organisation and paid in the organisation every 6 months to a year, depending on the size of the organisation. So reasonable care, why is actually that important? Well, so for a year we've had HMRC that have given the light touch for penalties, but for 22-23 is going to be the first year once it's closed, because obviously we've got to wait until the end of the tax year, where if there has been a failure to operate PAY in NIC, in addition to the interest that will be due and the liability, they will seek penalties unless reasonable care has been demonstrated. And that's why we got that. The penalties can be anything from 0 to 30%. I mean, it could be over 30% in cases of deliberate errors, but we don't really consider that to be appropriate. So it's like 0 to 30%. So if you want to reduce any potential penalties from the risks around the operation of payroll labour, we recommend that this mind map is born in place. Next slide, please. So with all of that in mind, what we've decided to do is to bring to life what that means in the public sector. So I've talked about it in terms of the rules, but what we want to do now is have a discussion with my colleague Caroline Jones, who's a director and also heavily involved in so obviously I've been through all of the rules there in record speed, I might add. And there's I mentioned about the fact that we've got the public sector in 2017 that went into the rules, and then the changes in 2021. What have we been seeing now from HMRC in respect of activity with the public sector? Is there anything particularly that you think our listeners would want to hear?
Yes, I think so. So HMRC have definitely been more active when they've been looking at employment status more generally. And recently they've issued, so just before Christmas, they sent a letter to most, if not all, local authorities in the UK, something that we would call a nudge letter. And basically what they're asking for is for local authorities, and it's not out with the possibility that this might extend to other public sector organisations, depending on what they find. So they've sent a letter asking them to look at all direct engagements, so that's self-employed individuals as well. And Caroline mentioned that there was a reduction in self-employed individuals down to 4.2 million, but still there's a lot in public sector. And what I've seen in particular is that in some parts of the public sector, the self-employed people actually outweighed the personal service companies. So you shouldn't forget about them too. But basically this letter is looking at direct engagements and off-payroll engagements via personal service companies. And it's asking local authorities to provide them with quite a lot of information in relation to those two categories of workers. So they're asking how many they engage on a self-employed basis, how many they engage on off-payroll, have they confirmed the status of all the workers that they engage, how many self-employed workers have been added to payroll, how many off-payroll workers have been added to payroll, and what date do you expect to add workers to payroll. So it's quite an extensive questionnaire, and we've seen this before. So although this is badged as not being a compliance review, basically they've done this before in local authorities with councillors' expenses a number of years ago. So some of you may remember that, and they've certainly done it in higher education with accommodation. So I think what we see is this is the first step towards perhaps targeting the public sector in particular in relation to off-payroll workers. Yeah. So you have to confirm that you've dealt with everybody. And I guess the problem with that, Jackie, is that if you don't answer, history shows that they are going to look at you because they're going to wonder why you haven't answered. If you do answer, you need to have your evidence because they did spot check when they issued previous nudge letters. So they might come and have a look. And then if you do, if you send your answer saying, well, actually, we've looked at it, and we think that we have got some issues that we need to tell you about, then HMRC treat that as a prompted disclosure. And you talked about reasonable care earlier on. Prompted disclosure can have a significant impact on penalties. So if you do something voluntarily, you tell HMRC you've got something wrong, you're going to put it right, then you'll be at the low end of the penalty scale. But if it's prompted, then it could be anything between 0 and 30%. So we're definitely seeing more of a focus by HMRC on status more generally. And of course, for the public sector, this has been an issue since 2017. So they have been looking at various organisations. And I think, you know, we just got to look at the recent DEFRA case, which was nearly 90 million, I think. So they're not afraid to go after their own government departments. I'm sure they're not afraid to go after the rest of the public sector too. So I think, you know, people really need to be thinking about what they're doing and are they dealing with these individuals and personal service companies correctly.
Wow, that's quite a lot to take in, actually. So, Caroline, in terms of those nudge letters, then are they putting a time frame on when you must respond or anything like that? Because I know that the private sector, certainly they've got like a 30-day time frame.
Yes.
Is that the same?
Yes, so it is. They've been given some very short time frames, but they issued this letter probably about 2 weeks before Christmas. So a number of my local authority clients have managed to negotiate an extension with them so that they can have a look at their processes. Now, you know, negotiating an extension and getting to the right answer is the right thing to do, but it also makes you think, is the revenue thinking, why do they need an extension? Can they not answer these questions because they've not got the processes in place? So I always think if you're not ready, definitely get an extension. But, you know, if you are able to answer, then do it within the time limits. But it is a very short time limit. And the other thing we shouldn't forget is the revenue can go back 4 years for tax, 6 years for national insurance. So once you send your response in, if you don't hear anything from HMRC for a few weeks or even a few months, don't think that it's going to go away because they can come back to you at a later date. So they're going to focus on the ones where they think they've got the biggest chance of recovery and where their biggest risks are.
So, okay, and then so one of the things I mentioned as well was about that identification piece and the interactions between procurement and finance and HR. And I know that you've done lots and had lots of conversations with public sector, and I wondered if you could elaborate that for me a bit.
Yeah, of course. So I think the thing is, in public sector, you know, they're huge organisations and very often they've got quite a lot of engaging managers. So you could have people from all parts of the organisation taking somebody on a self-employed basis or via a personal service company. The problem is that often what I've seen is that the status isn't considered at the outset. Sometimes it's only when it gets to payment that people start to think, actually, should this individual be on our off payroll, or should they be employees? So I think what I've seen in terms of those cases that are going through procurement, for example, one of my clients had a really pretty good process, they thought, in place to look at contracts and make sure whether somebody is inside or outside scope and all that good stuff. But we decided we'd do a training day with them, and what was really useful about that was that we had quite a lot of people at that training day. So we had people from procurement, finance, tax, HR, payroll, all sat around the table, and for about 10 minutes I didn't say anything, which, as you'll know from me, Jackie's quite unusual, because they all started to talk to each other. And what came out of that initial conversation is procurement deals with contracts of more than £10,000, and they review all those to make sure whether they should be on payroll or not. Finance thought that procurement did everything. So there was a huge gap in the below £10,000 contracts, and it wasn't until they all got around the table and started to talk that they realised that they did have a gap. So there was a significant number of businesses that had to be looked at quite late on in the day, really. So we're probably talking 18 months ago, you know, when we're looking back at 2017, there's already quite a big risk area. Yeah. So I think having a team who know what they're doing and who speak to each other regularly and having documented processes is a really good thing to do. And I do think that I've spoken to a couple of clients. In fact, I spoke to one last week, and they talked me through their process, and their process was really good, but nowhere was it documented. So I would say the other challenge is making sure that you document everything that you do and keep that, because HMRC would definitely want to see it.
Yeah. What do you think you would expect to see in a good, robust policy then?
So I think there are a few things that need to go in that policy, and that's around what engaging managers need to do. I've seen quite a lot of public sector organisations have their own questionnaire, which can be really useful. And engaging managers can use that, because the point is that those people who are undertaking those engagements know exactly what they're looking for. They know exactly what service is going to be provided and whether they're going to be provided with an individual or not. So the first step of that process, I think, is making sure that engaging managers are absolutely clear about the questions that they need to ask and that they test them. And the reason why I say that they should test them is, when this first came into the public sector, so back in 2017, there were a lot of individuals who said that they were going to go into the private sector. Right, I don't want to be part of this club, so I'm going to go and work in the private sector instead. So we saw a lot of that. But the other thing that we saw a lot of was we saw a lot of reliance on substitution clauses in contracts. Yeah. And HMRC have obviously got wise to that and have made the questions around substitution much more challenging. So there've been lots of things that, you know, if you've got a substitution clause in a contract, maybe an engaging manager wouldn't necessarily understand what that means. So making sure that your process details all that you've got a documented process in relation to appeals. So some of the things that I've seen in the public sector is that organisations may have a different person or team to look at the appeals, so an independent eye, because we have seen quite a lot of appeals coming through, and it can be really difficult. So I would say that that's something that you need to make sure that you document as well. And then the last thing is, when you're thinking about you know, whether or not somebody is self-employed or not, you really do need to go back to basics. So you mentioned statements of works. You need to go back to basics. Is this a personal service or not? And if you answer yes to that question, then you're going to have to apply the tests.
And I think it's very clear, isn't it, that a statement of works, there's a tendency to think that anyone who's through a statement of works is a supply of service, when actually it's almost just like an umbrella contract, and so it's the actual detail of that statement of work that needs to be looked at, yes. And there's quite a lot in order for it to be not outside of IR35 rather than a supply of labour. So anyone that's using a statement of works, we, you know, recommend that they are thoroughly reviewed to make sure they're comfortable they really are outside. Don't you agree?
Absolutely, and I think so. So when I'm trying to describe it to clients, because you know it is a difficult concept, isn't it? So
Yeah.
I often talk about contracted out services, and I always use payroll. Payroll get very offended, but if you outsource your payroll, then if you're outsourcing the whole of that service, then that probably falls outside IR35. Whereas if you're bringing a payroll person in, then that is a personal service. So is it genuinely an outsourced service? So taking that step back right at the beginning to understand exactly what you're asking for.
I think I'm going to use that example in the future.
Well, there is one thing that I think also we just need to mention is about supply chain due diligence. I think you mentioned that. And one of the things that I did quite early on when this first came out in higher education was said, actually, you know, you've got to do your supply chain due diligence because you now need to be able to tell not only an agency, if you're using an agency, but actually the worker in the personal service company as well. But I said, well, I think in higher education, you've got very small or short supply chains and it shouldn't be an issue. And I was roundly shouted down. So I don't think we should take it for granted that supply chains are short. We should think, well, actually, we need to understand each leg in that supply chain to make sure that we're doing our due diligence.
And it's not as easy as all that either, is it? Because you sometimes find that you're educating the supply chain as well as to the questions that they need to answer. So
yeah, exactly.
Very seriously. Okay.
Yeah, and could I just mention something on that? Actually, that's a really good point you made there, Jackie.
No.
So if somebody's providing a service to the public sector, an intermediary is providing a service, then they are within scope of the rules. So there's been a bit of confusion about the rules really when they extended to the private sector. So public sector, we absolutely know that the rules apply in the public sector. And then when they brought the private sector rules out in 2021, there was talk of it leveling the playing field, but actually it didn't do that because it was only medium and large size businesses that were caught by the 2021 rules. So you could have somebody who's working under the rules in the public sector and then working with a small organisation where the rules don't apply, and that creates all sorts of problems for contractors and confusion. But what I just wanted to say is that quite recently I've been helping a client in the public sector and they've engaged a personal service company through another organisation, and that organisation doesn't meet the criteria to be considered medium or large. And so they've said, well, we're outside the scope of the rules. So it comes back to what you were saying about educating your supply chain as well. So they thought that because they didn't meet the criteria, that they didn't need to think about the rules. But of course, they were providing people to the public sector. So they did. And that bit can cause quite a lot of confusion as well.
Yeah, I totally agree with you there. I've had quite a lot of conversations about people thinking that they are outside when it's only the end engager that needs to consider size, not the rest of the supply chain. Yeah, very much so. One other question. So I've mentioned about CEST and the 20% are unable to determine the answer. Do you think that is something that is a problem for the public sector?
I do, because it's those undetermined 20% that creates the difficulties for organisations. I would say that in some cases you do need to think about whether somebody's inside or outside scope. The information that you put into the CEST tool is really important. So one of the most recent organisations that we've seen in the public domain has had to settle with HMRC is DEFRA. And I think, as I said, I think it was about £90 million they had to pay. But they had used the CEST tool. But the revenue view is sort of rubbish in, rubbish out. So if you want to rely on CEST, you've got to be really clear that the information that you're providing is right. And sometimes I think there's a little bit of difficulty around understanding the CEST questions for some organisations. You need some consistency, because if you've got lots of different people making decisions, they may make different decisions based on the same set of facts, because they need sort of nuance really what the individuals are doing. So I think that's the first thing. The other thing is that you get some really senior people where perhaps, well, there's two things: that maybe it's unable to determine, or maybe it says they're inside scope. And you know, in your organisation, you think, actually, is that right? So I just thought I'd share something that I've been working on quite recently with a public sector organisation. And that is, we've got somebody who's been working with this organisation through PSC for the last 25 years, and they're project manager. And so when the organisation ran the questions through the CES tool, it came outside scope, but they really felt uncomfortable with that. So they asked me if I'd have a look at it. And so when I looked at it, first thing I did was I looked on their website, and it says meet the team, and this person was in the team. Project manager, as I said, for 25 years, not working for anybody else. And so it was quite clear when I worked through everything, all the details, and I saw the contract, that they were actually inside scope. And it led to a really, really difficult conversation in this organisation, because this person was quite senior. You know, and that in itself probably tells you that they ought to have been on payroll. But also people above those heads of department were really reluctant to have this person put onto payroll. So sometimes, you know, I've been used to say, well, Caroline said, rather than an organisation, somebody in the organisation having to say, well, actually, this senior person ought to be on payroll and get pushed back. They've used me to say that I've said that they're actually inside scope. And I suppose the thing that you need to think about there really is the potential impact on penalties. So we talked about reasonable care. So say, for example, I said to an organisation, I believe that this person is inside scope. And they thought, well, yeah, we agree, but we're not going to do anything about it because we don't want to lose them. They're really valuable to the organisation, and we're going to take a risk. HMRC will consider that to be deliberate. So if they came in and reviewed the processes for that particular organisation, they found this individual where advice had been sought and they'd chosen to ignore it, that's deliberate. And you're then talking at least starting at 30% penalty, probably significantly more.
Gosh, yes, I haven't really thought about that so much. I'd said earlier, haven't I, that we don't have clients that fall into that, but perhaps they fall into that without even realising that particular penal regime.
Yeah.
So we're obviously saying that reasonable care is very important. How do we make sure the organisation really does understand that? What's done in terms of, you know, the idea of training and keeping people up to date in an organisation?
I think that's really important, actually, and I've done several training sessions now for the public sector, one as recently as probably 4 or 5 weeks ago. I think training is really important to make sure that everybody is aware of what should be happening. We've just done some training and writing some guidance and a training manual for another client, because things do change as well. But if you've got some, you know, if you've got training set down, then it's easier to update that as things change, because case law is changing all the time. Yes. We're even in cases that have been taken to tribunal that have gone back and different decisions have been made. But if you've got that baseline training, it's much easier then, I think, to update the training to make sure that everybody understands what they need to do. And obviously you get new people in perhaps who have got, you know, got new responsibilities for off-payroll workers. What do you say to them? So having that sort of training document, or maybe regular training sessions, if you're a really big organisation, is a very, very good idea.
And I guess we would also sort of think that training shouldn't just be about how to use CEST, but also what the policies and the processes are, and making sure that everyone still understands what they are and that they're fit for purpose.
Yeah, and I think, you know, we should all remember that status isn't a matter of choice. There's lots of case law, there's lots of guidance. And so I generally would start with that, you know, it's why are we here? It's not a matter of choice. And just explaining what the consequences of getting it wrong are, because they can be quite frightening. Yeah. I mean, certainly I'm sure that the government departments have been fined or frightened, because they're massive amounts and you don't get an additional budget to pay penalties, etc. So it can have a massive impact on your budget too if you don't get it right from the outset.
Yeah. Interestingly, I had a look at HMRC's website this morning, the Employment Status Manual, which helps organisations understand the CEST questions. There's 35 pages of commentary on those questions. So it just shows how complex it is, doesn't it? And training is definitely something that should be provided.
Definitely. So, and there's sorry, Jackie, I was just going to say there are a couple of areas where people do tend to get to get it wrong, and that's around, you know, whether or not an individual has to incur any costs before they start working for the organisation. Yeah. And I think people think that that means that if they're paying for travelling, that needs to be taken into account, and it doesn't mean that. And the other thing is around vehicles. So I see quite a lot of mistakes around that. You know, do they have to incur costs to provide a vehicle? Well, that's not sort of commuting, should we say, back and forth to the organisation, but do they genuinely have to go out and lease or buy a vehicle to carry out the work that they're doing? And I think the answer I see quite a lot is yes, but the real answer probably should be no.
Yes, that's very true. Yes. So finally, I'm just going to, so we're employment tax advisors, but and we know that IR35 provides rules and governance around tax consequences. But obviously, if you've got someone who is deemed employed for tax purposes, how should one think about any potential rights that an employee might have under employment law, for instance?
Yeah, we get asked that quite a lot, actually. And, you know, we're not employment lawyers, but what I would say is it's really important for you, if you're putting somebody onto your payroll, that you use that OPW marker so that you don't have to take responsibility for things like student loans. So HMRC will know that they're not employees of the organisation, they're deemed employees. So using that is really, really important. But it's a very good point that you make, Jackie. And HMRC did say when they first introduced these rules that it wasn't going to confer any employment rights for individuals or personal service companies. And I have to say, as far as I know, HMRC don't make employment law in this country. So I think it's a bit of a watch this space. So at the moment, the talk has all been that it doesn't confer any rights, but I actually think that we might see that tested in the future. Make sure you use your OPW marker.
So that's the end of the questions that I have. Was there any last minute thoughts that you thought before I hand back to Greg?
I just think this is a really, really complicated area, and I think HMRC expect organisations to get this right. And, you know, it's a very grey area. Employment status has always been a grey area. I think it brings with it a lot of responsibility, but I think from my perspective, getting your people to understand the consequences of getting it wrong, making sure that they're trained properly is really important. And just the last thing, document everything. If you document it, HMRC comes in, they will see that and at least know that you are trying to take reasonable care.
Brilliant. Thanks very much, Caroline. So for the audience, hopefully that's given you sort of a bit of a flavour of how it actually works in the public sector as well as the rules there. So I'm just going to hand back to Greg now to close. Thank you.
Thanks, Jackie. And I've not seen any questions in the Q&A. So I'd just like to thank all of the speakers today, Alexandre, Bill, the two Carolines and Jackie, for what I hope you found an interesting set of presentations. We will send around a link so that others in your organisation who you think might need to see this can watch the video and hopefully learn from it. We'd welcome any feedback on the presentation today. We hope to run more of these in future. But thank you very much for attending and hope to see you next time. Goodbye.